Hello everyone, a very warm welcome to all of you. Today is Monday. I am Drishti and we are back again with yet another session of your Polity and Governance. Before we start, could you guys please comment and let me know whether I'm audible or not? Could you guys comment and let me know whether I'm audible or not? Okay, thank you. Now, today we are going to discuss a couple of very important topics which were in news in past week, right? And they are detrimental to both your prelims and mains perspectives, mains point of view. Also, I am going to give you one Seize the Mains questions. Seize the Mains is a free initiative where we provide you one question daily subject wise and you can frame your answer according to the question that has been asked. A couple of things we are going to discuss about the question right now, and the whole detailed answer you can find in our evening video where the answer is discussed in the detail. Whatever answer you're writing, you can post it on our website, right, to which the link you can find in the description box given below. Also, it will be evaluated there entirely free of cost by our team of experts, right? So before getting started, let's see the index today, index for today, what all topics we are going to discuss. So first we are going to discuss a couple of things about 9th schedule. 9th schedule has been in news. As you all know, the Constitution of India has been divided into a couple of schedules, and what is special about 9th schedule, how does it tiptoe around the basic structure doctrine, a very powerful case, Keshwananda Bharti case. We are going to discuss everything in detail. Right now, we do post the PDFs in the Telegram channel just after this just after the session. If you look into it, sorry about the cough. We do post the PDFs in the channel. Please, just after the session, look into it. You'll find the PDF by the name of Monday Polity, right? Okay. Now, second topic that we are going to discuss today is women's participation in the armed forces. Recently, judiciary has intervened. There was a case, there was a PIL regarding the permanent commission, short commission, and the discrepancies, the unequal behavior that is there with the men who are serving in the defense forces and the women who are serving in the defense forces, and there has been a middle path that has been found, and recently there has been a push for equal opportunity for women in the defense services. We are going to discuss everything in detail, how it started, how it has evolved, what all rules are included in it, right? We are going to discuss everything step by step. Also, we are going to discuss, your third topic is again with the armed forces. We are going to discuss a couple of things about Armed Forces Tribunal. Now, basically, you guys must have studied in polity what does a tribunal mean. We have different tribunals for different purposes. For example, when it comes to environment, we have NGT, National Green Tribunal. Similarly, we have Armed Forces Tribunal, where all the cases pertaining to defense services are judged, right? Be it court martial or any other such type of case, which is particularly in relation with something that has happened in the defense forces. So we discuss that. We are going to discuss that in detail, right? We are going to Vaibhav, kindly post your questions. I will try taking up your questions after the session, right? Whatever questions, whatever doubts you guys have with regards to any of your preparation or anything about the session, kindly post it in the comments and I'll try taking it up once the session is done, right? If I answer your questions right now, it is going to be a hindrance, so we'll take everything after the session. Right, now let's get started with our Seize the Mains question. The Seize the Mains question for today is, again, the question forms a part of your GS paper 2, Indian Polity and Constitution. Now the question says, give a critique of the evolution of the concept of judicial review. Okay, so you have to understand there are a couple of concepts, you must have studied them in polity. So it is judicial overreach, judicial review, right? So these are the concepts you must be familiar with by now. Now the question asks, give the critique of evolution of the concept of judicial review with a special focus on 9th schedule of the Indian Constitution. Answer in 150 words, so it's a 10-marker question. Now what you must know what a judicial review is. Also you must know what 9th schedule is, what does it enlist, right? If you don't know these basic terms, you cannot answer this question. And the basic part I keep on repeating every single week is try addressing all the parts of the question that have been asked. Do not miss any of the part of the question. If you want to have an edge, read the question multiple times and answer accordingly, right? Now let's get started. Now your first thing pertaining to this question only, the first news that we are going to discuss is Jharkhand reservation bill and 9th schedule of the Indian Constitution. Now why this was in news? Jharkhand Assembly recently cleared a bill to raise the total reservation in state government posts. Now state government posts, they have raised this reservation to 77%. And if you guys have seen our video of the previous week, there we discussed your 103rd Constitutional Amendment Act, right? 103rd Constitutional Amendment Act, and it also was pertaining to, it also was related to your reservation of EWS quota, economically weaker sections quota. Even there the Supreme Court had intervened, and we also discussed in very detailed what Indra Swane case was, how 50% capping is not sacrosanct, right? I hope you guys have seen that video. If not, kindly go through it. That you can find that video in our playlist. Now here if we talk about the Jharkhand reservation of vacancies in post and services amendment bill, basically it is talking about the government posts. So here they have raised a bill to raise the total reservations for your scheduled castes, scheduled tribes and your OBC, other backward other backward classes in the state post for the government posts up to 77%. The bill which is passed by Jharkhand Assembly basically says there needs to be a recommendation to 9th schedule of the Constitution accordingly. This particular 77% reservation breaches your 50% capping or upper limit which is set up by Supreme Court in the 1922 judgment of Indra Swane versus Union of India verdict, which is popularly known as your Mandal Commission report. Right now also, however, placing this legislation in 9th schedule, it shields it from the judicial scrutiny, which is seen as a major loophole in many of the laws. See, what is 9th schedule? We are going to discuss it in detail in the slides ahead, but basically you have to understand majorly what 9th schedule includes is, it includes your judgments that are pertaining to your landmark judgments, land judgments, abolition of zamindari. How it has evolved, let's see further. Right now in Indra Swane versus Union of India, as I told you, which was popularly known as Mandal Commission case, Supreme Court ordered the total reservation should not exceed 50%. But here what critics say is, according to critics, the 50% ceiling is a constitutional requirement without which the basic structure of equality of opportunity will collapse, which is the part of our, the essence of, the basic part of our constitution. Now here Supreme Court, as we discussed in your 103rd amendment, Supreme Court Constitution Bench majority ruling in economically weaker section case has said that the 50% capping is not sacrosanct, right? Now, what is the outcome of this judgment? The judgment has paved the way to give new life to argument of several states. There are n number of states who have been fighting for an argument. Basically, they want to increase the reservations for socially and economically backward classes. Majorly it's a political gimmick, majorly it is because they want to attract the vote bank politics, but major states have been pushing for it, and the states which have been surrounding Jharkhand, Chhattisgarh, particularly these states, for example Madhya Pradesh, Chhattisgarh, Karnataka, etc., not Karnataka per se, but these states have been pushing for the same sort of legislation, and now this is going to open a Pandora box, right? Also, it will give a fresh impetus for extending reservations to the backward classes beyond 50% limit, right? If we talk about 9th schedule, so before this economically weaker section judgment which came again, which was there again affirming the Indra Swamy decision, this does not specifically bar the breach of 50% limit. State governments, they considered this can be done only if they put the said legislation into 9th schedule. As I told you, it was seen as a loophole. 103rd Amendment Act we have discussed in detail last week. Also, what introduction of Article 15 and Article 16 Part 6 and 6 did, this was also discussed, so kindly just go through it once again. Now, if we talk about 9th schedule, it contains a list of central and state laws which cannot be challenged in courts. Again, these should be in line with your basic structure doctrine as put forward by your Keshwananda Bharti case, right? Currently, if we talk about the current scenario, so there are 284 such laws which are shielded from judicial review. Most of them are under the schedule which concern agriculture and land issues, which are state subjects and not the central subjects. If we talk about how this whole idea evolved, how this whole idea came into origin, so this became a part of constitution in 1951. In 1951, when the document was amended for the first time, here it was created by two new articles, 31B along with 31A. This was brought in by the government to protect laws which were related to agrarian reforms, which abolished your zamindari system, your benami transactions. It was related to these line of reforms, right? Now, here Article 31A, it extends the protection to classes of laws, and Article 31B. Article 31B, it shields specific laws or reenactments of the said laws. The first amendment added 13 laws to the schedule, and there have been continuous subsequent amendments accordingly, and they have happened in 1955, 64, 71, 74, 71, 76, 84, 1990, 1994 and 1999. Similarly, if you count the total number of amendments, there have been number of protected laws to 284, and this is where we stand today. Now, while the 9th schedule provides the law with the safe harbor from judicial review, the protection is not fully uncounterable, right? This can be challenged in court. Now, Supreme Court has said that in a verdict that while the laws placed in the 9th schedule cannot be challenged on the grounds of violation of fundamental rights, but they can be challenged on the grounds if they do not pass the test of basic structure doctrine of the constitution. Now, basic structure test की अगर हम बात करें, the court has clarified that the laws cannot escape the basic structure test if it is inserted into 9th schedule after 1973. Again what I mentioned earlier, as per Keshwananda Bharti case, and it acts as an ultimate test to examine the constitutional validity of the laws, right? Now, if we talk about some of the similar related provisions in the constitution which are related to this particular topic, also these are the articles you can quote in your answer for your to increase the quality of your answer, also to get an extra edge from other students. So, these are Article 16 Part 1 and 16 Part 2, Article 15 Part 1, Article 15 Part 4 and 16 Part 4, also Article 16 Part 4A. Okay? So, these are the topics you can go review once and accordingly frame a good answer. which will be checked, and then you can have the maximum benefit out of this whole process, right? Now let's move ahead to our second question. Our second question is women's participation in the armed forces. Now this was in news because Supreme Court recently directed Center and Indian Air Force to consider granting permanent commission to 32 retired women in short commission officers based on their sustainability, and ultimately the goal was to give them pensionary benefits after they have retired, their pensionary benefits. Now the court has refused to order their reinstatement as the service. That is the bottom line. So court ने ये तो बोल दिया है they will not be reinstated, but somehow the compensations that can be made are being accounted for. Now पूरा केस क्या है, let's see. What Supreme Court has said is, the bench has said that women Indian Air Force officers, if they are found eligible by Indian Air Force for the grant of permanent commission, they will be entitled to grant of one-time pensionary benefit. The key word is just one-time pensionary benefit from the date when they would have completed 20 years in the service if it had continued. Now you have to understand, even if they are provided with a pensionary benefit, now it is going to open a Pandora box of everything retrospective. Also, this is going to put an extreme burden on the state exchequer. So these all things have to be kept in mind, and accordingly a decision has to be reached. Now these women Indian Air Force officers pension will be equivalent to the officers who would have served for 20 years. Now एक तो ये issue आ रहा है. Also there was a case called Babita Punia case in 2020 where the case said that armed forces have discriminatory recruitment practices for women who were being excluded from positions that otherwise they were entitled to. So if these serving officers would have been men, they would have been entitled to better, more prominent working conditions, but because they were women, so this was a discriminatory practice. Now what happened was, it paved the way for an increase in the intake of women officers into the defense forces. Women in, if we talk about the basic structure, how defense forces work, so women in armed forces, they can serve a full career, earlier which was a maximum of 10 years. 10 years plus 4 years. Now 10 years was the mandatory serving period, and if a woman wanted to serve for more period, so she could have gotten an extension for 4 years, and उस 4 years के duration में they could have resigned at any particular point of time, right? Now if we talk about the whole evolution scenario of the women's participation in Indian Armed Forces, so they traditionally thought of as male battalion, and in past 30 years there has been a wide recruitment of wide induction of women in the forces. But if we compare it with the other countries, for example Israel, they have a mandatory military service period for the citizens irrespective of whether they are women or they are men, and they take part in all the roles, whether it is military role, whether it is combat role, whether it is field role, whether it is medical role. So they are made to take part in all the branches, and hence it helps them to inculcate a feeling of patriotism and serve their nation better. Now here if we talk about in India, military opened its door to women in 1992 when the Indian Air Force inducted its first batch, but still the combat roles were limited. In 2008 a permanent commission was extended to women in streams of Judge Advocate General and Army Education Corps. It was still not the combat role. Now came 2015. Here India opened new combat air force roles for women as fighter pilots. ठीक है, just as fighter pilots. So if you see, it was not a mainstream combat role. Now women have been allowed in combat in Air Force, but we are yet to see women in the same roles in Indian Army and Navy. Even though women have been in forces since 1992, all the roles are not offered to them, and this is majorly widely seen as a discriminatory practice. If we talk about the significance of inducting women in defense forces, so how it helps the society as whole, right? It will provide equal opportunity to contribute for the nation. Also, it will send a clear-cut message that the state is gender equivalent and there is no discriminatory practice in the state altogether, right? Now, we provide with gender equality in the forces, and the forces itself, they provide a challenging and fulfilling career to all its citizens. Already, if we see the recruitment practice, there are a lot of vacancies at very high posts in Indian defense services which need continuous filling up, but because the basic induction process and the whole the timeline of it has not evolved with time, so there the issues have been arising time and again. Also, if this is done, there is going to be a change in the regressive mindset of the society, and this is going to challenge a strong stereotype that only men, only males are fit for serving in the Indian Armed Forces. If we talk about what challenges are there that women face, now the basic universal military perception is that owing to operational, practical and cultural problems, women are unfit and men are more fit to serve in the Indian Armed Forces. Officers in the combat branches, they have to fight together, and there is no privacy, which could be an issue for a female. Also, if we talk about continuous sexual harassment cases in the defense forces, not just in India but also in abroad, that has come up as one of the major issues which needs to be addressed. Now here there is tough to maintain a proper living conditions for women. For example, if you're serving in Afghanistan, and women, they need certain things, medications, also owing to their menstrual cycles, they need proper equipments, proper residential services. So if it comes comparing with the conditions men and women can live in, it is more easier for the army to provide living conditions, comparatively very basic living conditions for men, and it is somehow hard to manage for women. So that has come up as one of the major challenges. Also, if we talk about the requirements of service, owing to the physiology, owing to the reproductive structure during pregnancy, motherhood, women have additional responsibilities as seen in our society, and that could be seen as a hindrance to them serving in the defense forces. And also the prolonged period of holidays that are given, that cannot be given to women, also can pose a hindrance. So there also this has been seen as a major challenge, and this needs to be addressed. Now there are going to be more developments in a couple of days in the same topic. Jab hoti hai, then we are going to discuss in detail. Now a couple of things you can see about short commission. I already told you about this. Now short commission ki baat kare, short service commission. So it provides an option to women for joining army as a service commissioned officer for 10 or 14 years. After 10 years, the women officer can either opt out of the permanent commission or have the extension of 4 years. During this 4-year period, they can resign anytime they want. If we talk about permanent commission, it means a career in army till the retirement age. Till the retirement age, whether it is 58 or it is 60, depending upon the position and the post you are serving, right? For permanent commission, the entry is done through National Defence Academy, which is in Pune, Indian Military Academy, which is in IMA, which is in Dehradun, and OTA, Officers Training Academy, which is in Gaya. Now, if we talk about what recent developments have happened in the case, so after the Supreme Court paved way for women to take the National Defence Academy exam last year. Earlier, the National Defence Academy exam was only open to the male candidates. It was not open to the female candidates. But here Supreme Court last year allowed women to take exam, and since then 19 cadets, 19 cadets have joined the Tribe Services Academy in Khadakwasla, Pune, which is your National Defense Academy, Pune, right? So these are the developments that have happened. Now let's see how it goes. But meanwhile, Indian Army needs to redress, Indian Armed Forces need to address this equality, gender equality issue, and the gender roles, gender specified roles, so that equally men and women can contribute to the nation and the feeling of patriotism is not suppressed altogether, right? Now we are going to discuss our third topic for today. Our third topic for today is, recently the Appointments Committee of Cabinet has approved appointments to fill 23 vacancies, which include 11 as judicial members and 12 as administrative members in the Armed Forces Tribunal. Now if we talk about what is Armed Forces Tribunal, so it was formed by the Armed Forces Tribunal Act of 2007 and it was passed by Parliament, which ultimately led to the formation of the body. Now the tribunal transacts its proceedings as per the Act of 2008. If you talk about the functions, it has the power which has been provided for the adjudication of trial by the armed forces of dispute and complaints with respect to commissions, appointments. It addresses appointments, enrollments and conditions of service in respect of persons which are subject to the Army Act of 1950, the Navy Act of 1957 and the Air Force Act of 1950. See, ये वाले जो acts हैं, ये वाले जो commissions हैं, issues हैं, they do not come in news, they are not in news for a very long period of time and we do not study them very regularly. So when any such topic comes, please make it sure that you have detailed notes of the respective topics, so that if the same question comes in UPSC mains, right, or your state services mains, you are able to give up, you are able to provide with some really good points there. Now it can further provide for appeals arising out of orders, findings or sentences of court martials held under the said acts and for matters which are connected to the whole incident in respect to the armed forces. Now if we talk about benches, the principal regular bench is in New Delhi, but the Armed Forces Tribunal has regional benches. कहाँ पे है regional benches? They are in Chandigarh, Lucknow, Kolkata, Guwahati, Chennai, Kochi, Mumbai, Jabalpur, Srinagar and Jaipur. So if you see, basically her zone mein they have provided with you with 2 to 3 tribunals, and similarly the whole case, the whole India has been divided as per the divisions here. If we talk about the appointments, the judicial members are retired judges of High Court judges and administrative members are retired members of armed forces who have the rank equivalent to Major General or above the rank of Major General and have the experience of 3 years or more. If we talk about the Judge Advocate General who have held the appointment for at least 1 year and are also entitled to be appointed as administrative member. If you talk about other features, all the proceedings in the tribunal, they are conducted in English. If you talk about normal courts, they are conducted in Hindi as well. Also, if there is a state specific court, for example Tamil Nadu, so the proceedings might be conducted in Tamil, right? Similarly, if it is Andhra or Telangana, they might be conducted in Telugu, but here if the proceedings are of Armed Forces Tribunal, they will be conducted in English and English only, because the armed forces take this language thing very seriously. Also, the tribunal will normally follow the procedure as is practiced in the High Court, right? So these were your topics for today. Please make a detailed notes out of them. I will just glance through the questions that you guys have put forward and address those. Also, if you have any doubts, you can mention them in comments. How to cover PIB for UPSC CSE? See, daily we give you your prelims booster in the morning. Also, the topics that we are covering right now, we make it sure that we cover the points from PIB as well. Otherwise, if you want to do it on your own, what you can do is, subscribe to the PIB Telegram channel of Government of India. You can also subscribe to the Twitter account. That will give you easy access to what is in news. Basically, if you want to divide it ministry wise, you can segregate them your paper wise. For example, your GS1 includes history. So, the Ministry of Archaeological Survey of India, everything, art and culture, उससे जितने related topic हैं, you can cover one day. Similarly, you can segregate them day wise. You can go through once PIB, and similarly, you can just update your notes. Also, everything is mentioned in very detail in the Hindu and Indian Express. So, I think if you're going through newspapers regularly, you're good to go. Pretty much everything else is covered. So, that shouldn't be an issue. Right, Vaibhav? Try doing this. If it doesn't work out, we'll come up with some other suggestion as well. Okay. KS Puttaswamy judgment, it also pertains to your Keswananda Bharti case and your basic structure doctrine case. And basic structure doctrine case mein there have been a couple of more case studies. For example, Keswananda Bharti, then there was Golaknath versus State of Punjab, Puttaswamy tha, theek hai. So these things, I think if you refer Lakshmikant, you'll be good to go. Everything is mentioned in detail. Also, Indian Express mein a couple of days ago, there was an article about the Puttaswamy judgment, because there was like, I think it completed 30 years or 40 years of judgment. So that was in news. If you cover that, you'll be good to go, right? So there are no doubts. Shubham, good afternoon. So I think we are done with the session. If you guys have any doubts, please mention them in comments. I'll try taking them up in next class. Till then, stay tuned and keep learning, keep watching. Post your answers, please. We'll be very eagerly waiting to evaluate them. And all the best for the exams. Bye-bye.